Hello, thank you for being here today for discussion / debate on healthcare in America. We've got a couple great speakers today, leaders in their field. But before we get started, I want to announce a couple other events that we have coming up. On April 1st, Professor Patrick Geary will be here to discuss the separation of church and state. And on April 20th, former Solicitor General of Texas, the Honorable James C. Ho will be here to discuss the pros and cons of birthright citizenship. So I hope all of you can make it for that as well. I'd also like to thank Andy Albertson and Michelle Payne for helping put this event together, and the Federalist Society National Organization for their support, as well as the John Templeton Foundation for their special funding for today's event and for the lunch. I'd also like to thank Professor Tashikawa, who's traveled here from Japan, probably for the pizza like most of you. But thank you for being here, Professor. I guess before we get started, the way that this event will happen, both speakers, or each speaker will take 12 minutes to present their side of affordable care or Obamacare, and each will have 6 minutes to rebut the other's presumptions and premise. So to get started, let me introduce our speakers. We have Ilya Shapiro with the Cato Institute in Washington, D.C., by way of Canada and Russia. Mr. Shapiro is Mississippi. Mr. Shapiro is a senior fellow at the Cato Institute and editor-in-chief of the Cato Supreme Court Review. Before joining Cato, Mr. Shapiro was a special assistant and advisor to the multinational force in Iraq on rule of law issues, and has practiced privately in international, political, commercial, and antitrust litigation. He's a regular contributor to a variety of media, including the Washington Times, the LA Times, National Review Online, The Daily Show, the Colbert Report, Comedy Central, CNN, Fox News, etc. Mr. Shapiro will be arguing in favor of the Constitution, liberty, freedom, and all things sacred.
Not all things sacred. I only have 12 minutes. But
12 minutes. 12 minutes worth of all things constitutional. Professor Loeffler, our very own Professor Loeffler here, is a leader in his field as well. Professor Loeffler teaches an introductory torts class, as well as health policy, bioethics, products liability, and a variety of other topics. Professor Loeffler's CV is also extensive, and we all know he's an institution here at Arkansas. So please help me welcome our speakers today. And at the conclusion of their presentations, we'll open it up for questions to the audience. Mr. Shapiro, Professor Loeffler, you'll go first.
I'm going to move over here so I can see his slides.
Good.
Well, thank you, Josh. Thanks to the Federalist Society for putting on this event, and to our distinguished guest, Mr. Ilya Shapiro, for coming to Fayetteville. He had to come through bad weather, a long delay in Chicago last night, and he got here for this healthcare reform debate. We really appreciate your presence here. Mr. Shapiro is clearly one of the nation's foremost and well-known critics of the new healthcare law. He speaks at law schools around the country. He's written friend of the court briefs attacking the law, and he's also an advocate at the state level. In fact, this January, he submitted testimony in favor of some unsuccessful legislation right here in Arkansas to take Arkansas out of the individual mandate. That was a bill officially titled the Arkansas Healthcare Freedom Act, but which might better have been labeled the Arkansas Healthcare Freeloaders Protection Act. And I'm going to have more to say about healthcare freeloaders in a few minutes. Healthcare reform is a pretty complicated subject to cover in a single hour, much less 12 minutes, but here's how I'm going to try to do it. I'm going to, my first turn, I'm going to speak to the merits of the new law, the Patient Protection and Affordable Care Act, which I will call by its acronym PPACA. And first, since its content has been so widely misrepresented and misunderstood, I'm going to briefly set out the facts about what the law does and what its impacts on Arkansas are going to be. Second, I'm going to address what everybody wants to hear about, the part of the law that says, come 2014, people have to have health insurance or pay a penalty or a tax. And I'll explain why that makes sense in terms of both ethics and economics, and why people like Mr. Shapiro, who want to repeal it or strike it down, are really lobbying and lawyering on behalf of the irresponsible freeloaders who want to foist most of their health care expenses on the rest of us. And then third, and this will probably come in my second turn up, I'll speak to the constitutional litigation over the law, as to which Mr. Shapiro is much more of an expert than I am. Now, here's how the Federalist Society publicized this debate, around the law school at least, and I love this. I think it's hilarious. And I see a lot of law students here, so I guess it must have been a pretty effective marketing tactic as well. But, let's get real. Here is what PPACA actually does. As most of you know, it has no socialism whatever in it. We are not setting up a national health service where most doctors work for the government, as they do in Britain. In fact, what we've got is an imperfect but more or less intelligent set of middle-of-the-road policies, many of which the Republicans themselves used to espouse before the Tea Party days. So, the first thing that this law does is it goes most of the way toward addressing the worst disgrace of American health care, the fact that about 50 million Americans don't have health insurance. Now, the law doesn't get us all the way there. It only reaches about 2/3, or not quite 2/3 of the uninsured. So we still won't have caught up with Western Europe, or Japan, or Taiwan, or Australia, or Canada, which all have universal coverage. But it does get us most of the way there. In expanding coverage, the emphasis is on primary care, preventive care, family medicine, the kind of care that will save hospital bills in the long run. PPACA outlaws the cruelest practices of the health insurance industry. Practices like yanking away your insurance if you develop a medical condition and need care, or saying, sorry, you've reached your annual limit or your lifetime limit, and we're not going to cover the expensive surgery or the chemotherapy that you need, or hiking premiums to unconscionable levels for people with medical needs. Every other country, every other advanced country bans those practices, and now, finally, America does too. PPACA sets up an organized marketplace called the exchange. So people who don't get insurance through Medicare, Medicaid, or their employer can comparison shop for their insurance through private companies. The idea is like going to Expedia or Travelocity to get your air tickets or your hotel. You go to the exchange for your health insurance. And it's open both to individuals and to small businesses. This is capitalism in action. It's better organized and better regulated so consumers and small businesses don't get screwed on individual and small group policies like is so common now. Now, expanding coverage to 32 million Americans who don't have it costs a lot of money, roughly $1 trillion over 10 years, at a time of serious concern about the national deficit. But that cost is paid for. Who pays? Well, most of the revenue comes from the wealthy people, couples that make over $250,000 a year. They get a 0.9% increase in Medicare withholding, a 2.9% increase in unearned income tax. Also, the companies that will benefit from all the new customers, the drug companies, the medical device companies, the health insurance industry, they have to pay in. The nonpartisan Congressional Budget Office estimated that in the long run, this bill is better than revenue neutral. It reduces the deficit. According to the CBO, scrapping the law would have the effect of piling on more red ink by far onto the federal budget. Now, this law is not perfect. It contains many a compromise, like any complex law. But I think it moves America in the right direction toward giving every American the right to at least a fair basic level of health care. Now, the Arkansas impacts. The law's nationwide benefits are evident, but the law disproportionately helps states like Arkansas that have relatively low income and lots of small employers. Most Arkansans in the private sector work in small businesses or for themselves, and most of them don't have health insurance as a job benefit. Now, here's how Arkansas compared with the rest of the country on health insurance through employment in 2005. And the numbers are quite a bit lower now in 2011. A lot of people have lost their employment coverage. So people have to go to the individual market where premiums are much higher. You get a worse deal for your money, if you can afford it at all, and the insurance companies often yank the rug out from under you when you need care the most. Mr. Shapiro, we've got more than 500,000 uninsured working-age people here in Arkansas. And most of those uninsured people, 2/3 of them, are not unemployed, they're not welfare recipients. These are people in families with full-time workers. So you might say, well, hey, they can always go to Medicaid. You get their health care that way. Well, if you think that, sir, you would be wrong. It's true that 3/5 of Arkansas children do get their health care through Medicaid, through our Kids program. But among adults, except for the blind and the disabled, you only qualify for Medicaid in Arkansas if you have income less than 17% of the federal poverty level. And for a family of 4, that amounts to $3,750, not per month, per year. So in Arkansas, if you're an adult and you have an income, your family of 4 has an income of $4,000 per year, Mr. Shapiro, you are too rich to qualify for Medicaid. Now, the health reform law is going to change all that. Instead of qualifying for Medicaid at 17% of federal poverty, it's going to be 133% nationwide, about $29,000 for a family of 4. And there will be federal assistance with premiums for people with incomes above $29,000 on a sliding scale. So basic preventive care, affordable care is going to be available to almost everyone. And right now, 5 out of 8 bankruptcies in the country are linked to medical bills. Under PPACA, that will largely be a thing of the past. Now we come to the most controversial part, the individual mandate. And first I'm going to explain exactly what that is, and second I'm going to explain why it's there. Third, I'll point out why Mr. Shapiro's solution, trash the mandate, would simply protect health care freeloaders and would undercut the whole structure of the law because of the operation of the vicious cycle of adverse selection. Now, here's what the law actually provides. First of all, U.S. citizens, legal residents, have to have health care coverage starting in 2014, or else they have to pay, you could call it a tax, a penalty, whichever. The amount of that is about $700 a year, up to a max of $2,100 per family, or 2.5% of household income. And note that that's a lot less than you've got to pay for health care insurance. That's how you can have the choice to go and pay that penalty instead. And the penalty phases in, starting with $95 in 2014, and then up to the rest of it in 2016. Now, so what you see is that mandate is really the wrong word, because you can choose to pay the penalty. Insurance is not compulsory. That's a point that critics of the law generally don't point out. So what it is really is play or pay. It's your choice. But as an ethical matter, people ought to play, even if paying the penalty saves them money. And here's why. For me, the point is personal responsibility. None of us can tell when we're going to be in a car crash or come down with cancer or some other expensive chronic illness that we don't have the personal resources to pay for, unless we're Bill Gates or somebody like that. Choosing not to buy health insurance that'll cover the cost you can't afford if you fall ill is the ethical equivalent of choosing not to buy the vehicle liability assurance that'll cover the cost you can't afford if you hit somebody. Simple as that. Well, you might say, even if I don't buy health insurance, I can always go to the emergency room, get care there. Well, that's true, thanks to the federal anti-dumping law. And lots of people do. More than half the acute doctor care visits made by patients without health insurance were to emergency rooms. But that's expensive, and that's not as good as regular primary care. You're missing the preventive care that would have detected the cancer or the heart disease, so you wind up with expensive hospital care and unnecessary illness and preventable death. And who pays for that expensive hospital treatment that could have been avoided by proper preventive care? Well, the uninsured do pay for some of it, about a third. And the rest is paid by government, by charity, by cost shifting to insured patients. In other words, by the rest of us. We all pay for it through higher premiums and taxes. So the people who don't buy health insurance are foisting their bad luck or their failure to take care of themselves on the rest of us. They're freeloaders. It's irresponsible. And this is a point that Republicans in the 1990s healthcare debate understood full well. This is a point that Republican Governor Mitt Romney of Massachusetts fully understood when he put through that state's reform, including the individual mandate. It's a point that Senator Charles Grassley, ranking Republican member of the Finance Committee in the Senate, fully understood in his negotiations over PPACA. And Mr. Shapiro, I always believed that libertarians stood for individual responsibility. But when you support the Arkansas Healthcare Freedom Act, when you seek the repeal or overturning of the individual mandate, then what you're doing is you're protecting the freeloaders' right to burden the rest of us with their risks. As Governor Romney said when he signed the Massachusetts law, a free ride on the government is not libertarian. So here's the point. The ethical policy recognizes that we all need health care. Everybody should chip in. Those that have a hard time paying for all the premiums, well, we'll help them out to some extent. I think that's the right thing to do. And Mr. Shapiro, I respect your right to disagree, so have at it. I'll talk about the rest of these points on my second turn up.
Is there a timekeeper or something? You're going to whisper to me or something? Like 2 minutes? Well, thanks very much for having me. I don't have any PowerPoint slides. In fact, I consider PowerPoint to be unconstitutional. And I hope all of you are enjoying your pizza. I know that's why at least the law students among you are here, and I appreciate that. I remember being a law student. But enjoy it while it lasts, because at some point in the future you might have to have salads for 7 days before you're allowed to purchase a pizza or something like that. And also, it's very interesting having this debate at the University of Arkansas, where my debate opponent's name is on the law school, his father, but still, it's a little intimidating. And of course, the place where the Clintons were on the faculty. Now, I was in high school when Hillary care was the issue. A lot of you, I guess, were in elementary school. I barely remember what the issue was, but I thought, I'm thinking about the Democratic primaries this last time around, and I thought that the Democrats did not choose the candidate that wanted to have the $1 trillion bailout of insurers and pharmaceutical companies and impose all this complicated new regulation and whatnot. Maybe Hillary was elected after all. We kind of live in a bizarro universe. But look, I'm a simple constitutional lawyer. I don't have the healthcare policy expertise or healthcare law expertise that Professor Loeffler does. In fact, I'll stipulate to every policy argument and healthcare regulatory argument that he wants to make. You know, you want to debate alternatives, policy alternatives to Obamacare, ask my colleague Michael Cannon or Mike Tanner or any number of people across the country who specialize in this sort of thing. This debate is not about health care. It's about the Constitution. It's about the first principles under which we live. It's about whether our federal government is one of delegated and enumerated and therefore limited powers, or one of a general police power like the states have. You know, I'm sure one of the few things that Professor Loeffler and I will agree on here is that the status quo is not acceptable. You know, the horror stories about Arkansas children being covered and, you know, making $4,000 a year, all that, you know, that's bad. We shouldn't have a situation where that's the case. You know, the technical legal term for our existing, you know, pre-Obamacare system is that it sucks. That's the term of art that I would use. Now, that doesn't mean that anything to replace it is either good policy or constitutional. And of course, those are two separate questions. And it doesn't mean that the only alternatives are status quo, universal government single payer, or Obamacare. There are plenty of different policy proposals that have been on the table. You can read Cato's. You don't like Cato, you can read, you know, other people's. There's different ways of reaching the goals of accessibility and coverage and, you know, cost control and all these different things. You know, we have a very perverted system. You know, nowhere in the world has your health care been tied to your employer. That's dumb. It's an accident of history because we had wage and price controls during World War II, and employers, to compete for workers, started offering perks because they couldn't increase salary, and one of those perks was health care, and that's where it was built. You know, get rid of that tax incentive for employers to do that, and you'll have a much more robust system for people to buy health insurance, just like they buy car insurance. You know, your car insurance isn't tied to your employer. You know, why should your health insurance be? Which raises the point about the mandatory car insurance, just to get that off the table. Two things there. First of all, it's states that impose that requirement on you, not the federal government. Again, states have police powers to legislate for the health, safety, and welfare and morals of their populace. Federal government doesn't, gets its powers, the enumerated 18 enumerated powers in Article 1, Section 8 of the Constitution. This is the Cato Constitution, by the way. It's a twofer. You get, by the Constitution, you get the Declaration of Independence for free. And secondly, if you don't drive, or if you don't drive on public roads, you don't have to buy car insurance. It's uncontroversial that driving is a privilege, not a right, and it's a choice. You know, states requiring someone to buy health insurance because they choose to drive is very different from the federal government requiring you to buy health insurance because you're alive. And I'm glad that all of you are here. I'm glad heartened by the continued sustained interest in this debate across the country, and the commentary and the email exchanges that I have, because you're clearly showing that you're wiser than, you know, Nancy Pelosi, who was asked you know, what she thought about the constitutional concerns, and the response, of course, was, "Are you serious?" Because the Constitution is the last refuge of the scoundrel that doesn't have any policy arguments to make. You know, we're in a post-constitutional world where Congress doesn't have any limits other than what it judges is in the general welfare. As John Conyers called it, the good and welfare clause. If Congress thinks it's good, then it's obviously constitutional, unless it make the argument that it infringes one of these so-called fundamental rights that, you know, they 5 judges take a vote on the Supreme Court, and then it becomes fundamental, and so forth. And that's why this debate is about federal power rather than individual rights, because the court's jurisprudence forecloses a lot of the type of freedom of contract and economic liberties and so forth, arguments that could be made on the right side. Now, on the power side, I was heartened to see, if any of you have read or skimmed at least Judge Vinson's decision in the Florida case last month, the 26-state lawsuit. There are now 28 states challenging Obamacare. Those 26 down there, plus Virginia on its own, Oklahoma on its own. That's unprecedented. I mean, there's a lot of things unprecedented about this case, but it's unprecedented to have a majority of states suing the federal government for, you know, something like this on a fundamental piece of domestic legislation. But you look at the beginning of Judge Vinson's opinion, before you even get into the legal analysis. And he quotes from my favorite part of the Federalist Papers, or maybe any part of political theory. Federalist 51, right? If men were angels, we'd live in utopia, we don't need a constitution, don't need anything, everybody's happy. If angels ruled over men, fine, we'd have perfect government, good, again, don't need a constitution, everything, we'd go about our lives, but the angelic government would do everything right. But in the real world, where it's men governing men, we first have to empower the government to govern in certain legitimate areas, and then check it, right? That's our whole theory. That's a whole basis on which this republic was founded. Checks and balances, separation of powers, federalism, all of these different concepts stem from the idea that we don't trust the government. Yes, we need it because the Articles of Confederation wasn't working. We need a central government to protect the national defense, to regulate interstate commerce. Wait, what does that mean? To make commerce regular. It turns out that states were putting up all sorts of protectionist barriers to trade among themselves under the Articles of Confederation. So clearly we need a federal government to strike down those barriers. That's the basis of the Commerce Clause. It wasn't a an authorization for Congress to start regulating. That's changed. That's shifted. But the original conception of the Constitution, one that survived even through modern doctrine, is that we are a government, the Congress, the federal government, has limited powers, and it can't go beyond those. There has to be some limiting principles. That's left, the other powers are retained by the states and the people. If the individual mandate, at least, there are other claims against Obamacare, but if the individual mandate is allowed to stand, ladies and gentlemen, then there are no principled limits left on federal power. You throw out the Constitution and you leave it to Congress checking itself. You throw out checks and balances, courts have no role because we have to defer to Congress and its wise judgment of what its own powers are. Because what is the government's theory that two courts have accepted, right? The kind of score, this isn't how we do law, but the score in the district courts are that 2 went for the government, 2 went for the challengers, right? And those are now up on appeal. But the government's theory that these 2 courts have accepted was that the decision not to purchase health insurance is an economic one that in the aggregate has a substantial effect on interstate commerce. Well, that's not a limiting principle because anything, the decision to do or not do, buy or not buy anything is an economic decision that in the aggregate has a substantial effect on interstate commerce. My decision to fly here yesterday, my decision to not go to Starbucks today, your decision to go to law school, what's more related to interstate commerce than your decision to go to law, your choice of a profession. We have a big immigration problem, right? So why don't we, with one fell swoop, solve that and solve the problem of us having a too litigious society by saying, this half of the room, you no longer can go to law school, you have to be gardeners, and then this half has to be busboys, and then we deport all the immigrants, and all these problems are solved because Congress can regulate these economic decisions that you're making. These are affirmative economic decisions. This isn't sometime in future that you'll need health care. You're already, in law school, affecting the interstate economy. This goes beyond anything that Congress, the federal government, has ever tried to do. Never, I repeat, never. And the CBO in 1994, when it was evaluating Hillary Care, said this originally. Don't take it from a libertarian think tank or what have you. Never has the federal government required people to buy a good or service under the guise of regulating commerce. It's unprecedented. Think about the foundational Commerce Clause cases, right? Wickard versus Filburn in 1942, the Agricultural Act setting quotas for farmers to grow their crops, and they have to take them to market. And this one farmer wanted to consume his wheat on his farm and not take it to market. And he was, set upon by federal agricultural agents and eventually fined. The court okayed that because if all the farmers who are engaging in this sort of economic activity of farming did this and didn't meet their quotas, didn't bring it to market, then that would have a substantial effect in the aggregate on interstate commerce. But nobody had to buy wheat, right? You could see Congress wanted to support the wheat farmers or have wheat provision. Everybody has to buy wheat. Or nobody had to become farmers, right? Fast forward to the 60s, the Civil Rights Act, or the Civil Rights era. The court decisions that if you run a hotel, you run a restaurant, you have to serve people without regard to race and other various protected classes. But nobody has to become a hotelier or restaurateur. And individuals in and of themselves are not economic enterprises. Fast forward again to 2005, the most recent Commerce Clause case. We moved from wheat to weed, right? Medicinal marijuana, the Raich case. There, under the Controlled Substances Act, the national regulation of drugs, Congress wanted to come in and shut down the personal growth and consumption of marijuana, okay, for medicinal uses. Legal under California law, under the state law. And the court okayed that because they were engaged in economic activity, growth and consumption. And if everybody did this, then that would foil the, again, national regulatory scheme. Okay? But never under the guise of regulating commerce or having a national scheme has Congress required people to engage in economic activity, to go into the private marketplace and buy a particular product. Okay, this is very different from single payer. This is very different from Medicare, which would be less problematic and probably under modern doctrine not problematic as a matter of constitutional law, as opposed to policy, which is a separate discussion, and then you don't want me here because I'm not a healthcare expert. I'm a constitutional lawyer. Whatever Congress does, whether it's good policy or bad policy, it's a separate question of whether the Constitution grants it power to do that. Okay, so the Commerce Clause, as I said, you can't justify it that way. This goes beyond, the activity-inactivity distinction. Just calling an economic decision swallows the whole. That doesn't leave any sort of limiting principle. Well, what about the necessary and proper clause, right? Because Congress not only gets to regulate commerce and establish post offices and raise armies, but it also gets to do things that are necessary and proper for exercising those other enumerated powers, excuse me. Well, it turns out that what we think of as the Commerce Clause doctrine, the substantial effects test, the outermost bounds, under Raich, under Wickard, whatever, the collected wisdom, as cabined by Lopez and Morrison, the short-lived federalism revolution, or as I call it, failed insurrection. That already discounts for the necessary and proper clause. Okay, you can't just, as Chief Justice Don Marshall said, you can't just build inference upon inference and have this infinite causal chain. This is necessary to execute this, which is necessary to execute this, which is necessary to execute this. Going back to Wickard and the cases from the New Deal in the 40s, Darby and LRB, all these foundational cases, they cite McCullough versus Maryland. They don't cite Gibbons versus Ogden. They weren't a redefinition of commerce. They were a redefinition of what it means to be necessary and proper, that you can regulate local activity when it has a substantial effect. And so you don't get a further necessary and proper extension. That's already included there. Moreover, Congress can't create its own necessity. It can't rub Aladdin's lamp and wish for infinite wishes, which is what the argument here is, right? Because you can imagine some sort of national regulation, be it of healthcare, be it of the auto industry, be it of the housing industry, which would only work if, insert your weird thing, right? The housing market collapses, so in future, everybody has to buy a Fannie Mae approved certain type of mortgage. You can't buy a house any other way to protect our national system of housing market. The next time the auto industry is in jeopardy, we have a regulation that works only if people are required to buy a Chevy, setting aside the issue of the government owning GM and whatnot. The same thing here. There's a fundamental difference between having the power to regulate an industry, here the healthcare industry, requiring coverage of this and that, having certain accounting principles in the auto industry context, seat belts requirements, fuel emission standards, and requiring you to buy that industry's product. That's a qualitatively different thing. So just because a 1944 case said for the first time, and nobody's disputing this, nobody's challenging this, who's attacking Obamacare, said for the first time that Congress can regulate insurance, whereas before it couldn't. Nobody's attacking that, but just because Congress can do that does not follow that then Congress can do anything that has the word health care or health insurance in the bill. And finally, it's been justified, well, I'll finish with the proper prong of necessary and proper. If you're curious, or Professor Loeffler raises the taxing power issue, I think that's a red herring, because this is a penalty. Obviously, when I tell you to do something, I'm not taxing you, I'm mandating, I'm commanding, but there's separate issues about why this isn't a tax, if it were a tax, why it's unconstitutional, et cetera. We can get into that if you're interested. No court has accepted this theory, even the ones that rule for the government. But on the proper prong of necessary and proper, okay? Just like the federal government cannot commandeer state officials to do their bidding. Okay, and that was for the first time in 1992 the court held this. There was never a state commandeering decision under the Commerce Clause or 10th Amendment before then. This violates the proper prong of necessary and proper because, again, there would be no limiting principle on federal power, destroys federalism, and Congress can't just go around commanding people to do things under the guise of regulating commerce. It can in certain narrow contexts. We know what mandates we have from the federal government. Serving on federal juries, filing and paying your income taxes, registering for selective service and being drafted. Of course, these are tied to selective, explicit exercises of enumerations of power. You know, not Congress exercising a power in some way to regulate commerce and then tying it to that. So this is, you know, if this is allowed to stand, then we throw away the Constitution. I guess I'm out of a job because there's nothing to argue about any limits or anything. You know, it's not the republic that I recognize even learning about even in my grade school in Canada. So thank you.
So Mr. Shapiro's passion carried him a little bit longer. We'll give you a few extra minutes.
No, that's fine. Thank you. I'm going to begin by confessing that I'm no expert on constitutional law. I'm not a constitutional lawyer, and Mr. Shapiro is. He's far better grounded than I am in the arguments and the precedents. So what I'd like to do here, then, as an amateur on that field, is just like to I'd like to share with you a general and admittedly sketchy outline of what some of the country's leading constitutional law scholars who favor PPACA are writing. And none of this is original on my part, but it does link to what I think is at least a sensible and defensible view of our constitutional structure. Mr. Shapiro said this debate is not about health care, it's about the Constitution. Well, it's about both. It's about whether the elected Congress has the power to, through the democratic process, try to fix these difficult problems of the healthcare system's serious deficiencies. And my position is that PPACA should be upheld as constitutional for two principled reasons, quite apart from the substantive merits or flaws of the law. First of all, the voters of the United States elected Obama and the Democratic Congress in November of 2008 to get health care reform done. And the legislative process was a spectacularly intricate and delicate one, but ultimately they did the job. This is how a republic works. No one is saying that Congress passed that law by any kind of illegitimate procedure. They didn't. They followed the rules. And for unelected federal judges to strike down this law, at the least, would be a profoundly disturbing invasion of the democratic process. But Mr. Shapiro and his allies say Congress overstepped the constitutional bounds here. He suggested that, well, healthcare reform really does need to happen. Coverage does need to be expanded. Well, so how are we going to accomplish that? Are we going to let the states do it? Are we going to let the states finance it because Congress doesn't have the power to do what it did? My response is that this is a critical national problem. not one the individual states can handle, especially not states like Arkansas. And our Constitution is explicitly designed to give Congress the tools to address national problems. Now, let's break it down into the Constitution's specific grants of Article I powers. As Mr. Shapiro pointed out, there are some different relevant provisions in Article I, Section 8. One is, of course, the power to lay and collect taxes to provide for the general welfare of the United States. One is the power to regulate commerce among the several states, and then the power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers. Now, regarding the taxing power, I'm not going to argue very much with Mr. Shapiro over that. There's little question that if Congress had enacted a law instituting, for example, a single-payer system like Canada's, and then paying for health care reform out of general revenue, and then covering the cost by raising the income tax or the corporate tax or whatever other tax, well, Congress would have had the power to do that under Article 1, Section 8, Clause 1. But instead of going to single payer, Congress decided to keep the private insurers at the center of the system and to pay for it, in addition to the increased unearned income tax and so forth, to help pay for it through the play or pay individual mandate. Now, does that count as a tax under the taxing power of Article I? Congress didn't call it a tax. I think probably they wanted to avoid the political fallout of saying that they raised taxes. I don't know what the courts are going to decide on this, but as Mr. Shapiro said, they pretty much focused on the other two, the Commerce Clause and the Necessary and Proper Clause. So, let's go to the Commerce Clause. And we'll start right off with the sharpest attack. Can Congress regulate the inaction of not buying health insurance? Can Congress say to us, play or pay? Well, the first point to observe is, again, being no expert, but it seems to me this is an unplowed juridical field. We don't have any direct authority one way or the other. The Supreme Court has never suggested that inactivity, that a play or pay mandate is somehow foreclosed from general congressional authority over economic matters relating to interstate commerce. Second, and Mr. Shapiro was candid enough to say this, there's a strong argument that individual consumers' decisions not to buy health insurance now, but rather to wait until they get sick or hurt and then try to pay the bills directly then, those are economic decisions that, in the aggregate, certainly do have a significant effect on interstate commerce. In fact, it seems to me that that fact is indisputable. Now, Mr. Shapiro and his colleagues raised the specter of government exercising unlimited power over individual choice. And some of his colleagues suggest that the division between acting and inaction is one good place to draw that line. But they would find a skeptic in none other than Justice Scalia, who in a different healthcare context had this to say. It would not make much sense to say that one may not kill oneself by walking into the sea, but may sit on the beach until submerged by the incoming tide. Or that one may not intentionally lock oneself into a cold storage locker, but may refrain from coming indoors when the temperature drops below freezing. Even as a legislative matter, Scalia says, in other words, the intelligent line does not fall between action and inaction. It's in Cruzan. So the point is, what affects commerce is a difficult line to draw, and a deferential court would honor reasonable legislative judgments about when economic activity is or is not present. Finally, the Necessary and Proper Clause. Now, here we go back to the reasons for the play or pay mandate. Most importantly, besides the ethical reasons against freeloading that I was talking about, are the economic reasons, and they're easy to understand. Requiring insurers to accept all applicants, regardless of health condition, is a primary goal of the law. To put together a big enough pot of money to cover the newly insured and the people that, under the present flawed system, are denied coverage or cut off because of pre-existing conditions, well, you got to have everybody paying in. You've got to include in the people that want to freeload. You've got to include in the healthy young people who think that they're invincible and won't ever get sick or won't ever be in a car crash. If you don't include them all in, if only the relatively unhealthy are in the insurance pool, then premiums go up, adverse selection takes over, more people drop out, premiums go up more, and it's the death spiral for cost control. That's just how the insurance industry, the insurance business works. So in other words, if moving the country closer toward universal health insurance is a legitimate national goal, and if we're going to keep a private health insurance industry in this country, then a democracy's legislative choice to help finance achievement of that goal through a pay-or-pay mandate is a necessary and proper exercise of Congress's Article I power. Thanks.
First of all, I should have touched on this in my opening remarks. Professor Loeffler said that buying insurance under the mandate or the minimum coverage provision isn't mandatory. You have a choice. You can either buy it or you can pay the penalty. Well, I'm curious whether you also have a choice when a mugger comes up to you and says your money or your life. We have a doctrine of unconstitutional conditions. We understand that at some point there's coercion, and here there's government coercion. What if you don't want to do either of those things? Just because the government could raise income taxes or increase Medicare payroll taxes and fund all sorts of different programs that way does not mean that it can also force you to buy health insurance or do something else. Each one of these is a different constitutional analysis, and it matters because the text of the Constitution matters, because without the government getting its authority from the Constitution, then it gets it from the point of a gun, and we just have majority rule. We have, to address Professor Loeffler's political point, a hugely unpopular bill from the very beginning that caused Ted Kennedy's seat in Massachusetts to go to a Republican, that caused the rise of the Tea Party movement. And we've had, that's such a weird couple of years politically, 90% of which is tied to the unpopularity, which unpopularity is tied to people understanding, not just disagreeing with the policy, but asking the question, where do you get the power to do this? There's a video of former, thankfully, Congressman Phil Hare of Illinois, who was asked this, one of these guerrilla, YouTube people, and he said, well, I don't care about the Constitution. I'm trying to take care of my constituents' interests, not understanding the contradiction between those two statements. Now look, the threat to democracy, the threat to our system of government and rule by consent of the governed does not come from courts striking down legislative action. They come from any part of government not fulfilling its constitutional duties. This whole debate about judicial activism just means a decision I disagree with. Conservatives say X, Y, and Z are judicial activist cases. Liberals say A, B, and C are. It doesn't mean anything. For a judge to notice that Congress is going beyond its constitutional power and do nothing about it, and do nothing, is judicial abdication. And if that's the position that Professor Loeffler or any of the other advocates for Obamacare take, then I guess they're against Marbury v. Madison and judicial review. What we're arguing is conflicting theories of the Constitution. I think we should all agree that judges should strike down pieces of legislation that are unconstitutional, either as going beyond the government's powers or violating individual rights. And I think those two are two sides of the same coin. Necessarily when the government goes beyond its powers, it violates the retained rights. Necessarily when rights are being violated, government is doing something it doesn't have the power to do. On the death spiral, freeloading, cost shifting, these sorts of policy arguments. I mean, first of all, again, to the extent there are valid policy concerns, that's a separate question from the constitutional angle. Yes, of course, you cannot require insurers to cover people with pre-existing conditions and not force healthy people to get into that same pool. I mean, by doing that, you, of course, eliminate the insurance industry. Our insurance industry with Obamacare is no longer insurance. It's publicly regulated, payment shifting and redistribution, and I don't know what you want to call it. Even before Obamacare, our insurance industry was more or less a public utility with guaranteed rates of return for insurers. And, their lobbyists, the big companies, they win either way. Don't worry or celebrate, insurers or pharma getting into the neck. They're winning regardless of what happens. But just because it's essential to that particular scheme that Congress has designed to have the individual mandate doesn't make the individual mandate constitutional or necessary and proper or any one of these things. You could have, this is where these broccoli or asparagus examples come up, right? Or, the buying a Chevy example that I gave. Let's say that, studies show that, scientific studies show, medical studies, that diet and exercise have a much greater effect on both healthcare outcomes and on taxpayer spending on healthcare than the ownership rate of insurance policies. So if anything, there's greater constitutional warrant to require people to buy, name your X healthy product, whether it be broccoli, asparagus, some other vegetable, or some other thing, or to join gyms. Now, there's a separate question about whether Congress could then, actually physically take that broccoli and shove it down your throat, or force you to work out on that elliptical, chain you to it or something. That's a slightly different question. But requiring to purchase that, I don't see a difference between. And as I said, there's a greater warrant for that than for buying the insurance. Scalia's healthcare opinion, I thought Professor Loeffler was going to talk about his concurrence in the medicinal marijuana case, which turns on activity and also turns on Scalia's drug war exception to the Constitution. But based on what Scalia's done since, he is not a swing vote here. I think he's firmly on the side of striking this down. And moreover, in the Cruzan case, that particular individual euthanasia case and whatnot, that there's no government coercion there. It's a fundamental right case. It's analyzed completely differently. I guess I'll clear up one other thing about necessary and proper, because I got into a little bit too much legalese. When I was talking about those early wheat cases, Wickard, the New Deal cases, why it's important that they were all citing Chief Justice Marshall's McCulloch opinion rather than his Gibbons opinion is because the former is about necessary and proper, while the latter is about the Commerce Clause. So, if you look at how Chief Justice Marshall talks about for something to be necessary and proper, you don't evaluate whether something is more or less necessary. And that scion of limited government, Alexander Hamilton, agrees. There has to be a line of justiciability. If you don't evaluate, well, that's necessary enough. That's not what you do. You see whether something comes within the letter and spirit of the Constitution. And precisely because there is no authorization for Congress to mandate things under the guise of regulating interstate commerce, McCulloch versus Maryland, and all the necessary and proper cases going back to our founding militate against upholding the individual mandate. Again, I can't emphasize enough. This is not about healthcare. There's lots of different markets that we can talk about. Everybody's the food market, the housing market. You need food and housing before you need healthcare. That Congress can do. There's lots of different things that Congress can do in the national healthcare arena. But this goes beyond any existing power under modern doctrine. And if this mandate is struck down, no other law, no other opinion, Wickard, Raich, nothing needs to be struck down with it. Because this is so singularly beyond anything that's happened. This so singularly eviscerates what remaining limits on federal power there are under modern constitutional law. That really, this is a turning point. And I think people recognize this, the overwhelming unpopularity. I think the latest poll, just of the mandate, not Obamacare altogether, but just of the mandate, is 70% people against it. That might help steal the spine of some judge or justice in the future. I can only hope.
We're going to go ahead and open it up for questions for anyone that's got a question for these
What you were talking about was very interesting, but the fact that we've got a table out here that's stacked heart attack high with pizza, with white flour, bad fat, salt, processed meat, says more about this issue than I think everything that you've said up here. Benjamin Franklin said, an ounce of prevention is worth a pound of cure, and that a stitch in time saves 9. You add up the fact that we can be healthy. Green tea is significant. Apples, blueberries, the simple things that are available to us right here at Walmart, everywhere, is significant. We don't need health care. We need to be healthy. Thank you.
If anyone
And that's
didn't
why
get
I
any
listen
pizza,
to my doctor rather than the government when I'm thinking.
you can get seconds when it's over, though.
So why doesn't the state of Arkansas, I mean, I was a resident of Massachusetts for 8 years prior to moving here. Why doesn't the state of Arkansas just do what Massachusetts did on the state level instead of asking the national government to mandate it, if you will?
Well, it's a reasonable question. The question is, why doesn't Arkansas, why don't the different individual states do it on the state level and fix their healthcare systems on the state level rather than leaving it to the federal government to accomplish? And there are a couple of points that you got to make about that because it cuts to the heart, really, of Mr. Shapiro's entire argument. This is a federalism question. Is this a matter for Congress to take care of, for Congress to address as a national issue, or is it something that is properly and necessarily left to the states? Good question. My answer to it would be that the healthcare problems that we have are irretrievably and inevitably national in scope, and that a single state can't fix the problems in and of itself, particularly states that have less resources, Arkansas being among those. We are left in Arkansas, as I pointed out, with a terrible situation of more than 500,000 people without basic health insurance. They cannot get it. And that foists burdens on all the rest of us, the taxpayers, and the people who are fortunate enough to have it. And these are issues that single state-by-state solutions, although they can serve as guideposts for other states, Massachusetts has done so, Utah, Hawaii has done so, they won't take care of the whole national problem. And so I think that part of what, for example, the Commerce Clause is all about is saying to Congress, if it's a national problem, then you may address it under interstate commerce, and you have the means, and their generous means, through the necessary and proper clause to accomplish that in some kind of rational way, in some kind of reasonable way. Now, as Mr. Shapiro said, there are many possible approaches to addressing those problems. Congress has chosen one among those approaches. As long as there's a rational basis for approving that democratic choice of the people that we elected, then the courts should not strike it down.
Well, this is why we're against Romney Care, and we don't hesitate in tweaking our friends at the Heritage Foundation for inventing that. And it's probably why Mitt Romney's going to have trouble in the Republican primaries the longer that this stays a salient issue. But states, as Romney said and continues to say, to try to kind of massage his point, states should have and do have flexibility to resolve their own policy issues as they like. I mean, what's more local, not even state, but local, than somebody going into their doctors to have a checkup, or somebody having a heart attack? That's very different than regulating an industry. Just like states are the ones that criminalize murder and robbery and rape and these sorts of things, not the federal government. Although the federal government has over-federalized a lot of different types of laws. For example, the federal carjacking law, right? It wasn't that carjacking was legal until Congress passed a law against it. It was always illegal to use weapons to steal somebody's car and rough them, It's not like any state allowed that. But just like in the Morrison case in 2000, which struck down the Violence Against Women Act, the theory there was when women are threatened or attacked, assaulted, that affects their productivity, which affects interstate commerce. And the court said, well, no, that's not too attenuated from economic activity. So similarly here, this is properly under the purvey of the states. And then, you get the issue of, whether one of your individual rights is to refrain from having to, that's a separate type of constitutional argument. But states, yeah, absolutely should have flexibility in this area as in many others that they enjoy about how to regulate different aspects of policy. Just because they don't doesn't mean that Congress says, oh, well, we see that these states are failing to do anything and therefore we get that power. That's not the way the Constitution works.
We've actually got the room for 1 minute, so we're going to have to wrap it up. But I encourage you all to read.
Is somebody else coming into the room?
We've got a class coming in here in just about 10 minutes. But I encourage you all to read the recent Florida opinion and let us know on our Facebook page whether or not Professor Loeffler's interpretation of the Commerce Clause is true and correct. I think that the Florida judge had his own theories on that, as did possibly the founders of this great nation. So thank you all. Thank you to the University of Arkansas School of Law and to our guests.